What is the direct effect in EU law? This is day 2 of my series, 10 EU law lessons in 10 days. The doctrine of direct effect allows individuals to immediately invoke a European provision before a national or European court. This principle only relates to certain European acts. If there is a conflict between a provision of the treaties and national law, the law of the EU has priority. This is known as the doctrine of supremacy and comes from the case of Costa versus ENEL, where it was held that the member states have limited their sovereign rights by joining the European Union. EU law consists of regulations, directives and decisions. Regulations are directly applicable and binding in all member states according to the Article 288 of the TFEU. Regulations are clearly intended to take direct effect without a need for further implementation. However, there may be cases where a provision in the regulation is conditional or insufficiently precise. It may also be the case that the regulation requires further implementation and fails the test for direct effect. Decisions are in the nature of executive acts addressed to the member states. The CJEU held that the decisions are capable of having a direct effect, as it was established in the case of grant versus financement. On the other hand, according to Article 288, a directive is binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods. This is day 2 of my series, 10 EU law lessons in 10 days. Follow me to catch lesson 3. In each lesson, I summarize key legal principles to save you weeks of studying and help you get a first class in EU law.